I want to talk about the Georgia case for a second. The first question is RICO statute, clever idea, makes sense, should be used, distorts the meaning of what RICO was intended for. And the second question is, do you think that Fani Willis, given the, the whole scandal, that she should have simply said, you know what, I got to step away and maybe we should find another district attorney in this state. Now remember, that's a problem because Georgia is sort of a purple state, right? Some of those DAs would want this case. She wanted this case. So I'm wondering, do you think that, her holding back and saying, the only one who's going to win it is me. No one else will take it. No one's ready for it. I want to stick with it, even if it looks bad.
I think it was certainly an unforced error to provide ammunition to anyone of a matter of this consequence, period. However, they didn't meet the burden of proving that she should be disqualified, and she's on this case. It's not as simple as simply saying, I'd like you now to handle it. In Georgia, it would go to a prosecuting counsel who then would decide who would take up the case. If there's no volunteers, then guess what? There'll be no volunteers. Then it could be assigned to somebody, which means that they don't have to be beholden to the grand jury decisions they've already had, to any of the decisions that they've made in the DA's office at all. It would effectively either slow walk or stall it indefinitely if it's ever brought at all. But at the end of the day, the same demand that the burden of proof be met as a criminal prosecutor has to be met in a different way with the disqualification. You had to prove there was a conflict of interest sufficient to mean that they could not have a fair trial. Now, I don't know whether Fani Willis truly keeps cash everywhere she says she keeps cash, or whether they went Dutch every time says they went Dutch. What I do know is that that has little to nothing, if at all, bearing on the ability of a defendant to get a fair trial. What they're trying to suggest is that they were maintaining their relationship, whether it was sexual or otherwise, because they wanted to be together longer. So here's a way, not a movie date, not a Netflix and chill, but let's have a 19 or 18 co-defendant case involving the former presidents. We can take a road trip, maybe one day to West Virginia. That's what they were arguing was the case here. Now, I have been married a while. I don't know how the young people date any longer. But that's not enough. That's not enough. And so they failed. She's on the case. Deal with it.
That was great.
And by the way, a lot of the people who are making the argument that it's outrageous that she's not recused or that this decision came down are in the same group of people who think that Clarence Thomas should not recuse himself when Ginny Thomas was involved in the way she's been involved in all the ways that you all are hissing about. I appreciate the hissing.
That was a trigger just now. Everyone's, ooh, Jeannie, ooh.
I mean, the other thing about the Georgia thing, though, is that I just wonder, I mean, first of all, the whole thing feels like a crossover episode of Law and Order meets Days of Our Lives. But
I was here for all of it.
But, even before the disqualification came out, there wasn't ever a date set. And that's always puzzled me. I don't know if you all have a thought on that, but I would think that would have been one of the first things that they would have been pushing for, and they just never did.
The date from the bringing
for the trial.
For the trial.
Yeah.
Yeah. I mean, she thinks it can happen this summer still. She's thinking, Fani Willis, by August. I think that's
not
it's a fool's errand to think of. I mean, a pipe dream. But I do think, I'm always so fascinated. Just to circle back, there was so much criticism about the audacity of Alvin Bragg to go first, quote unquote, and now in the end, he will go first.
Yeah.
He may be the only
one.
He may be the only one. Right. All right, we're going to get questions from the audience, but I have that last question I want. And, by the way, for CLE credit, I always forget. If you're getting CLE credit, the code to start the system was XRT564, XRT564. And at the end of tonight, the way you get your credit is NPL489, NPL489. Okay, I want to get back to this, what I call the 8.5 case, because I think that one is so huge, and it's a sleeper case, because it could end the whole thing. Now, the question there is, there's 900 people that are in jail for January 6th, and most of them are in jail not for seditious conspiracy, not for insurrection, but for this thing, that they interfered with the counting of the votes, that they obstructed justice, or in this case, a specific law of obstructing an official meeting while it's in progress. This law became the linchpin that put all these people in jail. Now, one of the people that bringing in the Trump defendants, one of the 19, is saying, you can't use that law against me. That law applies to corporations. It's a post-2008 recession law. It's about corporate malfeasance. It has nothing to do with political rallies and people going crazy. And I'm not responsible for that. It's a whole nother law. If the Supreme Court ultimately rules that this is a Wall Street crime and not a, Washington, D.C. crime, then it just seems to me not only does it knock out a major theme of the Mar-a-Lago, the Washington, D.C. case, the Washington, D.C. case for Donald Trump, but it might in fact knock out the same thing for all of the other people that were imprisoned.
So it may at the federal level. The state prosecutions are totally different under different statutes. Right. I think it's a hard argument for the defendants. Judge Carl Nichol is a very good judge on the trial court who did side with Trump and the Trumpistas on this. But basically, because the statute is written to say obstruction of an official proceeding, and that's the plain text, yes, it was passed as part of Sarbanes-Oxley after a series of corporate scandals and reforms, but the text is the text. And last time I checked, I thought it was conservatives who said we focus on the plain text of statutes and not the legislative intent or trying to divine what their purpose is. And so Trump and his allies are making a kind of legislative purpose argument, which is what the Supreme Court was known for in the 1970s. It's not today's Supreme Court, so I think it's going to put them in a difficult position.
All right.
But I don't think it's all, I don't know what the percentage is, but of all the January 6th defendants.
No, I think you're right, not all.
It's some subset of them.
Well, there's like the destruction of federal property. There's all kinds of things, attacking a policeman. There are all sorts of things, but it does seem like that.
But I think it's a big deal. I'm glad you talked about it. It's a big deal thing that's hanging in the balance and will affect the Trump case as well.
Yeah, it will definitely affect the Trump case in the D.C. All right, some questions?
Sounds like a bunch of patriots who should be pardoned.
They're hostages, Neal.
I think he's joking. All right, can you all comment? I love this question. Can you all comment on the impact of all of these cases on how the legal system is perceived by the general public? It's one thing for us, we're inside baseball. Yeah. But if you're not inside baseball, not everyone here, we have a lot of civilians here, you're saying, yeah, but it just doesn't look good. It looks like you're attacking your political enemies. It looks like you're giving Trump the high ground by proving to him that you won't let him campaign.
I think it makes people believe that the rich get away with anything. Mm-hmm. I think it's not about. I don't think. I mean, first of all, Biden's DOJ is not responsible for prosecuting the state crimes at all, and there's also. You can't very well think that Hur's decision is Biden's hand all over it, let alone Jack Smith. I do think people are frustrated with the notion of a quote-unquote Teflon Don, but it's not just him who is Teflon. It's anyone who's able. We're talking a lot about delay and the delay as a tactic. Every defense attorney has the right to be as zealous as they need to be for their client, even if it includes delaying, hoping for a different result. And I think that what people are seeing firsthand now in front of their eyes is that this is far more common to be able to navigate and manipulate the legal system to your will, provided you have the funds and unlimited resources to do so. And I think that's what people see about the system right now, more than politics.
To me, it's like I don't know what, the question is a difficult and complicated one, because I don't know whose perceptions we're talking about. The perceptions of the people in this room is one thing. The perceptions of the people who are supportive of Donald Trump is quite a different thing. And so if you're in the position that you think that the Donald Trump the grievance monster is correct and he's being persecuted, then every additional case causes you to retrench and believe that further. I mean, the data all shows that that Trump was fading as a political figure within the Republican Party. That's why all these people jumped in. And his political fortunes rebounded, beginning with a particular inflection point, the point at which Alvin Bragg decided to charge him, which goes against all the laws of political gravity, heretofore, right? So people are very polarized. They believe in their candidate, and people are very hard to persuade otherwise. No matter how brilliant we are in talking about the law and talking about the rule of law and talking about these cases, there's a perception on the part of not a small number of people, but tens and tens of millions of people. I don't have an answer to how you solve this dilemma. Tens and tens of millions of people their reaction to these cases being brought is to trust prosecutors less, trust the Justice Department less, trust the courts less.
So that to me, though, is why it's so important the cases occur and actually go forward, because Laura's point about how there's a fear that there's two tiers of justice and the rich get one set of justice, and Preet's fear, which is that the Trump folks will think this process is inherently unfair with every indictment. I mean, if you think about it the way our founders did, they said, hey, that's exactly why we architected the system we architected, which is prosecutors on their own say-so can't indict someone. You got to get a grand jury to sign off on it. Then there's a criminal trial in which you have the highest burden of proof, as Preet said earlier, imaginable, beyond a reasonable doubt, the highest standard in the law. All 12 jurors have to agree. It has to be unanimous in order to convict someone. You're going to have the right to counsel, including expensive defense counsel that Trump has. I mean, Trump has so many lawyers at this point. I think they're forming their own branch of government or something. But you've got all of these different protections plus the other things in the Bill of Rights. And to me, it's like, let that process unfold. Trump's so scared to let the process happen. But he has every advantage in that process. If you let it unfold, I do think, show that to the American people. I think that's the way to actually reduce the fear about people being targeted or things being unfair.